There's probably three reasons to have an irrevocable trust. First one being asset protection, protecting assets from a personal creditor or divorcing spouse. Number two would be minimizing any type of wealth transfer tax, such as an estate tax. And then three would also be some type of family governance, making sure that you're administering or using those assets that you leave to loved ones the way that you want them to be used. But things can change from the first time that you do some type of irrevocable trust planning into the next generation, the next generation, the next generation. And often with these trust vehicles, we're setting them up to be able to benefit multiple generations. But what happens when the intention or plan of the first generation, usually parents setting it up for the benefit of their kids or subsequent generations, what happens when that plan falls apart, whether it's a change in law, change in family circumstance, maybe just a change in the financial situation? So we're going to talk about whether or not you can add or remove beneficiaries from an irrevocable trust. So let's get into it. All right, can you add or remove beneficiaries from an irrevocable trust? And just as a reminder, a revocable trust is a trust that you can revoke, amend, restate. You basically can do anything you want to it. Really the benefit to it is that it helps you avoid probate just by changing the name of title on assets. But with an irrevocable trust, you're giving up a certain level of control of the assets and of the trust agreement. And so there's less flexibility with that trust agreement than with a revocable trust. So the question we're trying to answer today is whether or not you can add or remove beneficiaries from an irrevocable trust. Beneficiaries are those people that benefit from the trust. So usually when we see an irrevocable trust, we see parents setting it up for the benefit of their children. They'll pass the inheritance into the irrevocable trust, either during their lifetime or upon passing. And then the children will benefit from those assets. And when they're in there, they're protected from creditors. It's shielded from wealth transfer tax, such as estate tax. And then those assets can be managed and used however the first generation wanted them to be managed and used or benefited from. All right, so like I said, there could be situations where the beneficiaries might need to be removed or beneficiaries might need to be added. So here is a situation where they might need to be removed. Maybe a beneficiary develops a drug or substance abuse, alcohol issue. Maybe it's a gambling issue. Maybe there's some other type of issue that we can't really foresee. Okay, so that's one. Maybe they need to be removed, or maybe the distribution provisions need to be changed to account for that. Or here's another situation that we've seen. Kobe Bryant, when he passed away, he had done irrevocable trust planning, but he had not included his last, I believe it was his daughter. I think he only had daughters. His last daughter who was born before he died, he had not included that child as a beneficiary under his trust planning. So I believe, last I heard, that was going through the California court to try to get her added to that trust document as a beneficiary. So what options do we have here? So worst case scenario, no, you cannot change beneficiaries. You cannot remove or add beneficiary to an irrevocable trust. Old school trust planning, that was probably the thought, that was probably the idea. You set it, you forget it, you can't touch it, you can't update it. Or maybe a newer idea, or not necessarily the newest, but a newer idea is some type of judicial modification where you seek the court's approval to be able to add some type of beneficiary or remove a beneficiary. But you're going to have a very specific reason that is going to align with the discretion of the judge and any type of case law that there might be out there, or even just the statutes themselves that are going to dictate when you can add or not add a beneficiary. So what are more modern and flexible ideas or strategies around this? So two things come to mind. And the first one is a trust protector. I don't know if all states actually have trust protector laws, but most states, I believe, allow for what's called a trust protector. And this is a more modern creation under trust law. You've probably seen a lot of this come about in the last 10 years, 15 years, but a lot of attorneys don't use trust protectors for a variety of different reasons. So it's going to be up to each attorney whether or not they're going to include this. But typically the trust protector has the ability to sometimes, depending on the laws of that specific state, that specific jurisdiction, they might have the ability to add or remove beneficiaries. Now, that can have consequences. It can have negative tax consequences or estate tax consequences or other issues as well. And so also depending, so the state law will dictate whether or not, one, you can have a trust protector, and then two, what the trust protector is actually allowed to do. All right. And then three, some states, well, a lot of attorneys won't name trust protectors. And then another issue is whether or not the type of what's the word I'm looking for? The type of limits there are on the legal risk for a trust protector doing that. So even though they might be able to do it, they may not want to, depending on the legal situation, maybe with the beneficiaries or whoever else is involved. So these are all things to consider. So what's the other option? And I think this is the most flexible option available. Now, not all states allow you to decant assets from one existing irrevocable trust to another existing irrevocable trust. So when I say decant, what do I mean by that? So this is a term used in trust planning that means that you assign or move assets from one existing trust to another existing trust. Now, again, the idea here is state law is going to determine when you can decant assets from one existing trust to the next trust. And so maybe the new trust that you're decanting assets to doesn't have the same beneficiaries on there, or maybe it has different types of distribution provisions of that when distributions can be made to the beneficiaries. So in theory, if you don't like the first trust that you have and you want to completely revamp the trust, you could create a new one and then just assign the assets over. I'm not going into all the details about when you can do this, under what circumstances, but this is what to know. South Dakota has the most flexible decanting laws when it comes to moving assets from the first trust to the second trust. So what happens, what we see a lot is when maybe a family has a trust that's been around for many decades or even longer from another jurisdiction, and that law prevents them from being able to decant assets to a new trust. Well, what we do, usually what we can do, depending on what the trust agreement says, is we're able to move the trust itself, re-domicile it to South Dakota, and then it becomes governed according to South Dakota law. And then once we get it under South Dakota law, we then have the ability, for flexibility, we have the ability to now decant assets from that first trust to a new trust. But that really only exists under state law. So that's why we have to move it to South Dakota. So if you watched any of my videos, you know I love South Dakota law. You know that I think it's the best. I think objectively, it is the best trust jurisdiction within the United States. And this is just one more reason why it is. Can you add or remove beneficiaries from an irrevocable trust? The answer is it depends, but you definitely can in South Dakota, and you have the most flexibility to be able to do that under South Dakota law. So if you have an old trust that no longer works for you, if it's governed according to a state that has laws that are not flexible, it's worth looking to whether or not you can move that trust, re-domicile it to South Dakota so you can add new beneficiaries, remove new beneficiaries, or decant assets from that trust to a newer trust that has the beneficiaries that you want, whether it's individuals or even charitable organizations. So there's a lot of different things that you can do under South Dakota law.